Hello everyone, my name is Sarah and my group members are Lukman, Harpreet and Satnam. Today we are presenting on the topic ESIC versus Saffron. It is a popular case that saw a good demonstration concerning the corporate law. The case involved investment commission that saw the High Court dismissed appeal made by the Peter James Saffron, who was the general counsel and the company secretary of James Hardy Industries Limited. Saffron failed to reach the acceptable degree of diligence and care to prove that he was the reasonable leader by doing against decision that contravened Section 180 in regard to the Corporate Act 2001. The conduct submitted by the Mr. Saffron was handled considering his position as the company general counsel. Following the contravention of Section 180, Saffron also failed to make a proper advice as either the COE on the board of JHIL. Saffron observed that the company should have made a disclosure in regard to their involvement in Australian Stock Exchange. Following the rejection of his argument by the High Court, Mr. Saffron's responsibilities as the Secretary of Industries and that saw him play two roles alongside being counsel. Examination of both tasks the Saffron dealt was responsibility scope in this case study. The High Court observed that it was not possible for Saffron's responsibilities to be deduced from an examination involving kits and tasks of secretaries belonging to the other companies and doubted whether the company would perform. Saffron was found guilty of the breached company contract terms and was punished by being disqualified from the managing any corporation from next 7 years, while enduring a penalty of 50,000. Now my friend Harpreet will continue the case. Thank you.
In this case study, the issues that were considered include the extent at which the obligations and releases under 180 of the Corporate Act 2001, how the company's managers managed to fulfill, and the questions that the High Court considered in ruling out an appeal by Mr. Peter Saffron. Observed that the High Court had taken an important guidance involving external specialist advisors' decisions on enumeration of the responsibilities that overlapped and to determine the extent to which they would go. The High Court also observed that a person who incurs a duty as officer by taking should be investigated for taking part in decision making. The other issue is that the roles of the company secretaries who had specialized skills extended beyond the duties of the pure company, explaining the use of acquired specialized skills. The facts in this case show that Mr. Saffron was never formally appointed to the secretary of the company until November 1998. Mr. Saffron was legally employed by the Hardy as both the secretary and the general counsel of the company. Mr. Donald Cameron was later employed in 1999 to become the joint company secretary of Hardy alongside Mr. Saffron. Mr. Saffron breached Section 180 of the Corporate Act because of failing to give proper advice to the board of Hardy that involved an actuarial report that saw the board of directors lines to separation and consideration while the proposal hardly catered for it. The cost of claims debt rose at a greater annual rate than the actual inflation promoted superimposed inflation. Mr. Saffron also was accused of failing to advise the chief executive officer as Hardy as well the board of Hardy that ascertained added information in regards to separation of AS6 disclosure. Now my friend Lukman will continue the case.
The question in this issue is whether Section 180 only apply to the sectoral duty of the company alone. Zubretta observed that the court found that Mr. Saffron was greatly compromised on whether he had the ability to clear the duties of secretary as well as play the role of general counsel. The court therefore ruled out that it was not possible to serve the responsibility of Mr. Saffron in regard to Waterlight, compromise the mark him as the company secretary while the other are recognize him as general counsel. There was never any evidence show that Mr. Vance had a capacity to perform some tasks in other tasks for the role of one company in the other company, maybe mix up. However, evidence provided Mr. Cameron function had no proof on whether Mr. Saffron function in the company had anything to do with administration. Now my other friend is continue.
The court came to an agreement that the decision made were relevant to the finding of the courts of appeal and thus did meet the test by the court. The court found Mr. Saffron guilty for breaching the duties term and therefore rejected the argument by Mr. Saffron in regard to the claims that he breached his duty owing to Section 180 of the Act. In regard to the issue of access, Mr. Saffron observed that he actually did not possess actual skills relevant enough to run the function of the company. The cost of the claim was rising faster while inflation rate increased. Mr. Saffron's failures to account for the likelihood of having the validity of the accurate report summarized would not meet the suggestion relevant meet that the board had not made an attention in regard to the made provision.
In conclusion, the ESSEC vs. Chevron is a popular case that portrays a good demonstration concerning the corporate law. In this case study, the issues that were considered include the extent at which the obligation and diligence under 180 of the Corporates Act 2001. The court found Mr. Chevron guilty for breaching the duties and therefore rejected the arguments by Mr. Chevron in regards to the claim that he breached his duties on Section 180 of the Act. Thank you.